Hello, I am Margaret Levi, and I am Director of the Center for Advanced Study in the Behavioral Sciences, known as CASBS, and Professor of Political Science. I co-direct the Ethics, Society, and Technology, EST Hub, alongside my colleague, Professor Rob Reisch. The EST Hub is jointly managed by CASBS and the McCoy Family Center for Ethics in Society. I want to welcome you all to the first discussion in the EST Hub series, Unintended Consequences, Conversations about Ethics, Society, and Technology. The goal of this new conversation series is to amplify the significant work happening on campus to identify and understand the potential ethical and societal implications of innovations in science and technology. Today's conversation is on the pressing ethical and societal issues facing scholars in the field of law and medicine, a topic to which our two guests today have incredible expertise and insight. Let me quickly introduce our esteemed guests, Professor Hank Greely and Professor Michelle Mello. We will post links to their extended bios in the chat, so I will be very brief here. Hank Greely is Professor of Law at the Stanford Law School, obviously, and a professor by courtesy of genetics at Stanford. He is also the director of the Stanford Center for Law and Biosciences. He recently published an insightful and beautifully written, and believe it or not, funny, in the sense that it occasionally makes you chuckle, new book called CRISPR People, The Science and Ethics of Editing Humans. And we will be discussing that book as part of today. Michelle Mello is a professor of law at Stanford and holds a joint appointment at the Stanford University School of Medicine in the Department of Medicine. She is the author of more than 200 articles in medical liability, pharmaceuticals and vaccines, biomedical research ethics and governance, and many other topics relevant to today's discussion. And last night I learned that she was an honors student at Stanford who worked with Deborah Satz, our Dean of Humanities and Sciences. We will begin this discussion today with a few minutes of opening remarks from each of our guests, and then open up the conversation. I will jump in with questions from the audience as the conversation progresses. Please submit your question using Zoom's Q&A feature, and try to keep your questions concise and to the point. And we'll try to answer as many of them as we can. And we will be sure that the panelists will get the questions that we don't answer. We're going to start the conversation off by learning more about the areas Hank and Michelle study, what brought them to these topics, and what the key ethical and societal issues they find are at the center of their work. I'll start with Hank.
Thank you, Margaret. It's a pleasure to be here and to be with my colleague, Michelle. Law and medicine, we both work in law and medicine. It may sound like a fairly narrow area, but like almost every field and subfield, it has subfields and subfields and subfields fractally on to infinity. And although Michelle and my work overlaps to some extent, and we share common knowledge and common vocabulary, we really work on different things. Why I work on what I work on is really a product of, in part, my interests and in part chance. I was hired at Stanford Law School in 1985 to teach oil and gas law, which was a wonderful subject, really bizarre law, but I quickly turned it into an energy law class. In the meantime, though, I'd married a doctor, so I started teaching health law. And in 1991, 30 years ago, I decided I couldn't do both. I needed to pick one, and I made lists of pros and cons. And on energy law, I said the big issue is going to be climate change, and we're not going to have the political will to do anything about that. So that would be 30 years of frustration as a career. Whereas in health law, we're going to get universal health coverage in the United States really soon, and that'll be really exciting. And so I picked health law, and then Bill Clinton was elected, and we were getting universal health coverage, and then we weren't. And after the Clinton health plan crashed and burned, it was pretty clear there wasn't going to be big healthcare reform anytime soon. Meantime, though, the Human Genome Project was starting up. And I kind of got pulled into that by colleagues here at Stanford, including Paul Berg and the late Luca Cavalli-Sforza, and found that I really enjoyed it. It played to my interests in science. So for the last 30 years or so, almost all my work has been in what I call law in the biosciences. Sometimes I get identified as a bioethicist. I try to push back against that because I'm really a law professor who works on these issues, some of which are bioethics issues, some of which aren't. Things like patent law in biotech has some ethics implications, but much of the issues aren't really ethics issues. Specifically, over the years, I've probably worked most on genetics-related issues. That's what I started with in 1991, 1992. And genetics is involved in much of what I do. That also has led me to assisted reproduction issues, which show up both in CRISPR people about human embryo editing, and in my earlier book, The End of Sex and the Future of Human Reproduction, which is about human embryo selection. I work on law and neuroscience and neuroethics. I was one of the founders of the International Neuroethics Society, and that's really fascinating stuff. Neuroscience makes genetics look simple. It's like an order of magnitude more complicated. I work on stem cell research issues. I work on human subjects research ethics issues, but in a sense, and this has become more true for me as I've gotten older, I think what I'm mainly trying to do is try to help build a field that I call law in the biosciences. Our Center for Law in the Biosciences has fellows who then go off to be academics working in the field. We've got, I think, 20 academics around the world who've been our fellows in the last 18 years or so. So that's what I do. I think I have a relatively benign version of academic ADHD. I get distracted by cool, shiny, bright objects. And being a law professor, I don't have to get a grant to study them, and I don't have to pay for a lab to study them. I can just go off and work on de-extinction if I want to. So I have a fairly broad, and I hope not too shallow, range of issues around law and biosciences. Ironically, I think what Michelle does is more important than what I do. But what I do fits with my interests and is not unimportant. So I'm happy with the way my career has turned out. But I do think that the closer to health policy stuff is more important in today's world. And so Michelle is more important in today's world.
That will turn to Michelle.
Thanks very much. I'm really happy to be in conversation with you both today. I'll just say a couple of minutes about what I do and maybe a few things that I'm working on now that might spark some conversation in the group. There were several things that really drew me to this field, right at the intersection of law and medicine, health policy, and ethics, and that I think that make the field of enduring interest. One is that health is fundamental to human flourishing. And I first got interested in it because I was interested in how we get people the things that provide them with a chance for mobility, for opportunity in life. Of course, health is one of those things. And of course, the United States is exceptional among industrialized countries in our utter failure to secure that for our populace. The second issue is that I just find it fascinating that technology, which I would define broadly to include novel therapeutics and innovations in healthcare, has been responsible for some of the most important demographic shifts in the last 200 years of human history. And that includes our longevity, which has, of course, changed radically from where it was 2 centuries ago, and more than doubling of the human lifespan in industrialized countries, as well as what epidemiologists call the epidemiologic transition, or the shift in the developed world from a state in which what was killing us was primarily microbes, infectious disease, to a state in which what is killing us is primarily our own lifestyles and behavioral choices. We now are much more likely to die from chronic disease or from injuries related to our lifestyles than we are from infectious disease, the last year notwithstanding. And that is such a fundamental shift, and we now see that shift being exported to lower middle income countries. And technology, lies behind it. The third really important issue to me is, as a lawyer, just the disjunct in the pace with which the law evolves compared to the pace with which technology evolves, and the enduring challenge of trying to get law, which is inherently slow moving and slow to adapt, to wrangle and regulate a very fast moving pace of technological change that is always going to present huge challenges for us. And finally, I'm drawn to this field because I trained as a social scientist. My PhD is in health policy, and I trained with a bunch of health economists. And I realized pretty early on that there was this new field growing out there that was seeking to use social science methods to analyze data about how the law works and about how ethical issues are playing out in the ground. And that's really exciting, to not just write about these issues, but to make discoveries about how humans are interacting with the healthcare system, how laws are creating health outcomes on the ground. And so I've been really proud and privileged to be part of the growth of that field of empirical health law research. So there's just some background about what brings me to these kinds of questions. Let me now just summarize a few of the things that I've been working on lately and we might have a conversation about. Certainly in the last year, as all of us in health policy have pivoted to working almost exclusively on issues related to COVID-19, one of the issues that has cropped up in terms of the role of technology is digital epidemiology. For the last quarter century, we've been making increasing use of novel data sources from outside the healthcare and public health system to try to understand how diseases spread and how and to what extent various public health interventions are effective in stemming them. So I've gotten very interested in the various ways in which the global community has been using technology. One that you may have been hearing about more than others, being here in Silicon Valley in particular, is digital contact tracing, or the use of newly developed apps on smartphones to understand who is coming into contact with whom and to use that technology to try to stem the spread of COVID-19. It really raises some fascinating issues about human-centered design, about privacy, informed consent, and about process for developing technologies that are invasive but also potentially really impactful in a pandemic like this. So I've been writing a little bit about how you build this in a way that will win public acceptance and be useful, which are not always pointing in the same direction. Things that are useful tend to be more invasive and therefore harder to win public acceptance for. And I've been especially interested in some of the process issues around that. All of this technology has largely been developed in private without public processes involved. And how could we do better next time? A second issue that I've been working on since before COVID is the project of modernizing health privacy regulation. We have a structure of laws that regulate information privacy in the healthcare domain, and I think almost every privacy scholar would say that it has reached obsolescence. That there are several fundamental premises about that regime that arguably don't apply anymore. One is that as long as data are de-identified, we strip out personal identifiers, they don't present risk or major ethical concerns. It's increasingly recognized with the advance of computational technologies that de-identification is at best a temporary state. We're really good at triangulating data now and re-identifying people. So all of our privacy laws basically are premised around the assumption that if you just strip out identifiers, there's nothing to worry about, and that's not true anymore. Another, I think, important premise is that the most sensitive information that we have and that needs protection comes out of our healthcare system. And today, most of us are generating data that are as sensitive, if not more sensitive, just through our everyday online activities and the surveillance that becomes possible through our carrying of cell phones. So our old assumptions about what needs protecting the most maybe aren't true anymore. And then finally, there's been this obsessive focus on the idea that individual consent or permission giving is the right way to approach data privacy. And anybody who spends time online knows how hollow some of those permission giving rituals can be when we're asked to click through agreements. And so I'm interested in thinking about more enlightened ways to think about public permission giving or deliberation, at least, about data uses. Third area that I've been interested in, that some surgeon friends have gotten me interested in, it has to do with the use of recording technologies in medical care. They have brought to my attention two interesting trends. One is that patients are increasingly asking to audio record their own medical visits. And the other is that hospitals are increasingly video recording surgeries. Both of these practices raise really interesting issues about data ownership, about privacy, both of patients and of the medical teams that are performing procedures and giving medical advice, and about an old interest of mine, the interface between ethics and the medical liability system, because both of these practices cause a lot of concern among physicians about how that data might be used in a lawsuit or where else it might go, including onto social media. So I've been interested in thinking about how we can govern that area, because both of these kinds of recordings clearly have big benefits in terms of helping patients process information about their care, understand what's happened in their care, and helping providers do quality improvement. You know, surgeons like to watch their own videos, and not just because they have big egos, but because they learn a lot, sometimes very negative things about their own performance. So there are clearly big benefits, but how should we be thinking about governing that area? A fourth issue that I've been working on for the last few years is regulatory approaches to overpricing of prescription drugs. This is a phenomenon we're all interested in and aware of. Before COVID-19, it was Americans' #1 domestic priority for the Congress. And, you know, this is an area where the results of new technology are tragic, in the sense that we have innovation that brings incredible health benefits, but they are not equally accessible because of the unaffordability of a lot of prescription drugs to everyday Americans and our failure to provide adequate insurance coverage. So I think that area raises really fascinating questions about what we trade off when we have a system that promotes innovation by allowing expansive intellectual property rights and puts the United States kind of alone among industrialized nations in not regulating the prices of prescription drugs. And so what's the right balance in the trade-off between innovation and affordability or accessibility of the resulting leaps in technology in healthcare? And then the final issue that I'll mention, which is probably where I'm working most right now, is in strategies for maximizing uptake of vaccines. This has long been a kind of a core issue in public health law, thinking about in particular the role of vaccine mandates in making sure that kids receive classic childhood vaccinations. But of course, the topic that's most salient right now is how we reach those who haven't yet chosen to take the COVID-19 vaccine. So there are clearly legal interventions that can be imposed here, up to and including requirements. But I'm interested in kind of the space in between where we are now, a purely voluntary regime, and where we might go in terms of requiring vaccines, or what are the other mechanisms that might be used either in the private or the public sector to encourage people to take the vaccine, and how do we apply the legal and ethical principle of the least restrictive alternative, seeking that policy which burdens individual interests the least while still achieving the public health goal. So those are just some of the issues I'd be happy to talk about, and I'll close there.
Well, thank you, both of you. So in listening to you both and in knowing something about your work, it seems to me that both of you are very concerned with technologies, though very different kinds of technology. So in Hank's case, it's really bioengineering and CRISPR and those kinds of techniques and advances. And in your case, Michelle, it has much more to do with the digital, though there are other kinds of technologies involved there as well. And both of you are really involved with the ways in which the law is lagging behind where the science and the health expertise is going. So I guess my first question to you really has to do with the law and how you're thinking about really getting the law to be more in line with what the real processes are right now. But the even bigger question there, in which I hope you'll both address, is that the law is not always the same as the ethical implications, and changing, the capacity of the scientist and the health experts to really meet certain kinds of ethical obligations, and for the public to sort of understand what they are. So maybe you could talk a little bit about some of both the legal issues that have to be fixed and how that then relates to the ethical problems which can't be covered by the law. It's a really big question, but gives you a lot of opening for whatever you want to say. And whichever of you wants to pop in first on that, and feel free to discuss it with each other as well as with me. And so, go, I can see your mouth open.
Yeah, and I'm not muted. I guess one of the things I've learned from 30 years in this area is some of the limits of law and some of the ways in which law is not the only or necessarily the best tool. There's been a surprising amount of relatively effective regulation through voluntary organizations coming up with guidelines and guidances. For example, stem cell research pretty much all over the world is ruled without much in the way of legal backup by guidelines put out by a National Academy of Sciences committee in 2005. People self-organize in ways that can be useful. This is particularly true in these hot bioscience areas that are international. And the idea of international law, of getting meaningful treaties that would be meaningfully enforced in this space is, I think, on the edge of delusional. So law there across national borders is going to be very hard. I think that we need to think hard and try to exploit non-hard law alternatives. I also think, though, that there are places and things the law should do and can do. Sometimes it's not that the law is behind. Sometimes the law is actually too far out ahead, and they end up doing things that turn out not to make sense as the technology advances. I remember when Dolly was cloned, the Brits very quickly and smugly announced, well, human cloning is illegal in the UK and has been for the last 7 years. And that was kind of right, except the regulation that said that had defined cloning in a way differently from how Dolly was made, so it didn't apply at all. So I think we need, on the legal side, to focus on systems that can respond quickly to changes, that can take into account scientific nuance. I think we need administrative expertise and regulatory expertise in here. Which means I think Congress should focus more either on very, very broad principles or on setting up these structures rather than trying to micro-regulate on its own. But I also think that, and we've seen this tension increasingly in the US and elsewhere. We also need, this cuts against my grain. I'm basically, temperamentally, I think I'm a technocrat. But science doesn't have all the answers. Experts don't have all the answers. Science with a capital S needs to remember that it's necessarily part of the societies that it lives in and needs to respond to them and ultimately take orders from them. And so building in better ways of public engagement in discussions, I think is important and is something that is becoming increasingly important as trust in science and all expertise has eroded in the last few years.
So Hank, I'm going to follow up for just a minute and then we'll go to Michelle, because I too believe that there is a lot of value in self-regulation and various forms of voluntary organization. But as you document very well in your CRISPR book, he or hey, as you was not particularly susceptible to those self-regulations. And this is and as we know from the vaccine hesitancy problem, not everybody is willing to comply or cooperate with whatever become the prevailing norms of the society. So we need to think of mechanisms, maybe legal, maybe otherwise, to one, hold people feet to the fire, and two, to ensure that our procedures are in fact accountable.
So I think there are times when that certainly will be necessary. There are also worries about whether it will be feasible, whether the appropriate legislation can get through, or whether once you send something to Congress or a legislature someplace else, what you get out of it is worse than what you started with. Which in recent years with gridlock in the American Congress has been a concern. But I think we also need to recognize that legal structures aren't universally effective either. Murder's been illegal for a long time.
Right, absolutely.
It still happens. So I think, there are a lot of different mechanisms that can be used. And sometimes the most promising aren't law. Sometimes law has to be involved.
Great. Michelle.
Well, I think that's a really useful discussion. I'd just add a couple of points. I mean, I think that the largest challenge that we face right now is the fact, as Hank alluded to, that Congress is essentially broken as a governance mechanism, that we just can't expect useful law to come from there. So we have two other places that we can rely on right now for law. One is administrative agencies, which for the past 4 years have also been broken. You know, they have not been staffed by people who know what they're doing. That is changing, and so I expect to see that as a pretty robust area of useful lawmaking in the health and healthcare arena over the next 4 years. But the other is the states. You know, the states have been very active in all kinds of public health and healthcare law initiatives. The trouble is they're you know, as we all know from reading the paper, wildly divergent in their approaches to governing public health problems. And so the reckoning that has to be done there is how much diversity do we want to tolerate, or can we tolerate, as to their willingness or ability to address really the tough problems that are burdening vulnerable Americans. But just to add to the interesting discussion about non-law mechanisms of governance or accountability, I really see two big challenges going forward. One is how we make law more evidence-based. This was clearly a major concern during the Trump administration, but it's a longer standing concern because a lot of times the way agendas for legislative and administrative bodies get set are not based on a formal needs assessment, where's the most important areas for us to act, nor are they based on an analysis of what works or what plausibly should work in public health and healthcare. But as I alluded to, there's this field now that has dedicated itself now for the better part of a quarter century to evaluating law and helping policymakers understand what works. And so I think the challenge is shifting particularly the attention of legislatures towards that evidence base and away from the influence of vocal interest groups or whatever legislative priorities individual state senators might happen to have by dint of their personal experience, towards identifying what the critical opportunities are for health improvement and what the critical interventions are that we know works. And I think the second big challenge is understanding better how law plays out on the ground, particularly in the public health and healthcare realm. It's one thing to understand that we have a good idea in principle. It's another thing to understand things like incomplete implementation and inequities in the lived experience of people who are subject to the laws. For example, just to go back to my privacy regulation example, with terms of use seem like an efficient mechanism for collecting individual consent to data uses, but we know that people don't read them, and we know that people with lower educational status are disproportionately less likely to read them. With regard to a lot of other public health initiatives, we know that they might have beneficial effects on average, but might disproportionately burden particular communities with which we have special concerns regarding equity. So a lot more attention needs to be devoted to understanding that experience, and part of that is going to mean greater inclusion of those communities in the process of evaluating laws.
So
Can I follow on one thing that
Please.
Michelle said?
Yeah.
So if I could make if I could make any change, it might not be this one, but one plausible change in how legislation is done would be to make sure that all legislation comes with, attached to it, monitoring mechanisms to see how it's working and what's happening with it. It reminds me in a way of university building fundraising. It's fairly easy to raise money, fairly easy. It's plausible to raise money to build a building. Nobody ever raises money to maintain the building or to staff the building. That's not something that donors give to. Members of Congress want to have bills with their names on them that are doing exciting things that get headlines and get them reelected. But whether it works or not, that's not as big a deal to them, because that'll be played out uncertainly over a long period of time. So continuous monitoring and recommendation, a mechanism for recommending revisions as things go on, I think would be terribly useful. Sunset provisions may be one aspect of that in some cases, though they have their problems too.
But part of what you're suggesting here, Hank, is very consistent with what Michelle is concerned about, which is creating the evidence that we need to really make good policy and to sustain or get rid of the policies that should be gotten rid of.
Right. I thought it was an extension of Michelle's point.
Yeah, no, absolutely. So one of the issues both of you raise in slightly different ways has to do with engagement and engagement of the relevant publics for whatever process is going on. And maybe you could speak a little bit more about what that would look like in some of your domains, Michelle, but and Hank in yours, which is, genomic editing, certainly in the stuff on sexual reproduction. I can see where engagement could be quite important. In the genomic case, I think there's a different kind of argument about engagement, but I'd love to hear you both talk about what engagement means in these domains. Maybe start with Michelle, if that's okay this time.
Well, I think it depends vastly on what issue we're talking about and what community we're talking about.
Right.
If I could go back to the example that I raised in the introduction about digital contact tracing apps, there we're talking about any engagement at all that is transparent and public. So, those apps were developed very quickly by private companies, very well intentioned, I should say. I've spoken with many of these companies, and I believe their interest in trying to be helpful is very sincere, and they really felt like they were doing the very best thing that they could possibly do. But there was neither time nor inclination nor expertise to engage in a process where they could ask either the public generally or minority or other communities specifically questions like, what's important to you in the design of an app like this? How can we make this beneficial to you? What should it include aside from surveillance? For example, should it be building in ways to connect you with services and supports that are helpful to you as you navigate the aftermath of being told that you've been exposed to COVID, things like this. So, broadly for cases like that, we're talking about a process of consultation and inclusion in the development of policies and technologies. In other instances, I think we have to think about more representative approaches because it's not really feasible to directly involve the public in a lot of decision making. When I think about, for example, uses of health data that tech companies might contemplate or universities might contemplate in partnership with tech companies, I actually don't think consulting individual patients every time a use is contemplated is the best approach. But can we think about making greater use of data use committees that are composed of representatives of important stakeholder groups and are tasked with reviewing individual projects that would make use of patient data? Right now, the structures that we have to review research don't touch a lot of those projects, and it's not all research. So we need a new kind of structure that can be informative, that has expertise, but also has representatives of the public involved.
I'm going to make a little public announcement here and a little, so one of the things that the Hub has been doing, the EST Hub, has been trying to develop an ethics and society review process as research is developed in science and technology to think about the ethical implications and societal consequences, including whose voices should be involved in the process. So we are in the process, hopefully, of developing a new way of going about assessing research and helping researchers to achieve the kinds of goals that you're talking about. Hank, do you want to get in here?
Yeah, and so in the world I work in, the engagement issues may be a little different from the ones Michelle's
Absolutely.
talking about. But I think there are, I guess, three things I'd say. First, notice of proposed rulemaking is not an opening for public comment on a formal administrative law mechanism is not a good way to get significant public engagement. The NIH has a moratorium currently on some kinds of human, non-human chimeras. They put that out for comments. They got 20,000 comments, almost all of which were identical two-sentence condemnations that somebody had put out and asked people to send to NIH. That's not very meaningful. I think that one important thing that science can do is to talk more in advance about things that are happening or are going to happen that they know are going to be controversial. I think it's very bad for science when suddenly there's a headline about, human monkey embryos made, or babies cloned, babies CRISPR'd, or sheep cloned when nobody knew it was coming. Now, to be fair, some of that should have been, there were hints, but science tends to be really confidential and secretive, in part because, for understandable reasons, nobody wants to get scooped. And yet, I think if the public knew in advance, which means basically if science journalists knew in advance and were able to get the word out, there would be less shock and, in some cases, hysteria. I remember the wildly overwrought reactions to Dolly the sheep, which went from one sheep to armies of cloned warrior slaves very quickly in the public discourse.
Right.
I think that would be a good thing. And then the third thing is, I do think that formal methods, serious methods to try to get an understanding of what the public thinks about various controversial bioscience issues are important, but they're hard. The Brits have actually done this in some good ways. They had a long-standing effort at understanding what the population thought about something called mitochondrial transfer, a reproductive technique. And a nonprofit organization there called the Nuffield Council ran a bunch of surveys, meetings, focus groups, and picking on something that's highly developed here at Stanford, deliberative democracy kinds of forums that led to an assessment of what people thought. Ultimately, it ended up being decided in Parliament on a free vote where the parties weren't whipping their members to go one way or the other. And that the sense of what the public thought and why, and a more or less informed public, I think really helped there. I'd like to see us do that more. The Pew Trust funded something at Johns Hopkins during the aughts that did that with genetics very nicely. But that kind of work, if you're going to do it well, is expensive. And there hasn't been a lot of money for good, thorough job of it. I think that's something we should spend more time on, both because I think it's good for science to not get out ahead of the public too much or not shock the public too much. And as a matter of democratic governance, I think
Absolutely.
ultimately it's good for the people to have control, and to have control, it's good for them to know more about it. It's not to say that 95% of people are going to understand CRISPR. You're not going to get there, but you can do a lot better than we've done so far.
No, I love the fact that you're both arguing that part of the answer to this problem is a better informed public, and creating the capacities to do that. Let me switch the topics a little bit. One of the things that you raised, Michelle, was pharmaceuticals and prescription drugs and the high price of them. And this makes me think again that, the law is, and the regulatory apparatus is clearly part of what has to be brought into place to deal with this, but it's also an international problem. And it can't be solved simply by what you do in one country. And this brings us back to Hank's concern about how well we can be served by international law in some of these domains, and where we need international cooperation. So maybe we could talk a little bit about the pharmaceuticals and prescription drug problem. Either of you want to, Michelle, I know you're thinking a lot about this, so why don't you get started, and Hank can respond or not.
I mean, I don't work too much on the global aspects of this, but I'll say a couple things. And one is that the major instrument of international law that we have that relates to pharmaceuticals has the effect of keeping prices high, because the
Right.
TRIPS agreement obligates all member states to respect intellectual property laws, and that, it just serves to reinforce the patent protections that companies have that can permit them to charge high prices. But having said that, I do think this is heavily an issue of national law. And it's important to recognize that unlike many other areas of health and healthcare, the U.S. is probably like one of the worst in the world in terms of trying to grapple with this issue legally. This is not a case where we've succeeded so well here and we need to figure out how to bring this success to the poor and huddled masses of the world. No, most other countries do a much better job than we do of regulating prices, notwithstanding patent protections. And they're able to do that because they have national healthcare systems that purchase drugs and that have control over prices in their capacity as payers. So I think we need to fix our own house here before we purport to worry about inadequate law in other countries.
Well, one of the things you raise here, and I know that Hank has a lot to say about this as well, is the issue of patents and the role that patents play in affecting both science and health. In your case, we've just heard about it with the pharmaceuticals, so there may be other instances in which it plays an important role. In Hank's world, there are all these patents and patent fights about CRISPR, but also around various reproductive technologies. Maybe you could both address the patent issue a little bit.
A little bit, although we're fortunate in that we've got two spectacular colleagues who work a lot on patents and innovation policy in Mark Lemley and Lisa Willett, who are really at the cutting edge worldwide on thinking about these things. I guess first I'd like to say something about the pharmaceutical pricing, and that, Michelle is so right. U.S. drugs cost 50% more than they do in most of the other developed world. And that's because our government has, one party is a wholly owned subsidiary of pharma and the other is a partially owned subsidiary of pharma and bio, the big trade associations. The political power of the biopharma industry in the US has been successful at keeping prices substantially higher here than anywhere else. Much of the rest of the world has prices under more control. And then you've got the poorer parts of the world where the problem is whatever the prices are, they're not going to be able to afford them. So it's really, there's a problem at the bottom economically, there's a problem at the top economically. Many countries in between seem to be doing pretty well. On the patent issue, it's an interesting and difficult one. Where empirical evidence would be really nice to know just how important this incentive is to create. How much of a benefit do you have to provide in order to encourage people to make new discoveries? And one of the things that makes it hard is we have one patent law with a few minor exceptions. It covers everything, but the semiconductor industry, the software industry, have very different relationships with patent law than the biotech industry or than the pharmaceutical industry. So it's hard and it's complicated. There is some low-hanging fruit, particularly in the US in drug and biologicals regulation, where patents are clearly being abused to keep monopoly positions in place for years after they should be. The world's biggest selling drug is something called Humira, which is owned by AbbVie. Their main patent ran out in 2016. They have managed through patent litigation and settlements to keep all competition out of the United States until at least 2023. So that's 7 years, and they've been averaging $15 billion a year of sales in the US there. That's low-hanging fruit, except pulling it off the branch is hard. That's an abuse, but fixing the abuse has turned out not to be easy.
Michelle, anything you want to add to that?
Yeah, I'll add three things really quickly. First, I completely agree that our biggest problem in the drug space is patent abuses. There, we just have very, very low standards for granting drug patents, and some really strategic behavior by the drug industry to take advantage of that fact. And that has led to a situation where we are granting far more intellectual property than was intended, and that probably is necessary to incentivize innovation in the U.S. The second point, though, is that, as Hank alluded to a little bit, patents aren't always the problem when we think about the developing world. Patents, as I mentioned, don't preclude price regulation, but as a result of price regulation, it often is not in companies' interest to sell products in lower income countries because the prices are just not high enough to merit the testing and application processes that go on there. When we looked recently at the extent to which FDA-approved drugs are actually marketed in the countries where they were tested and developed, the rates are surprisingly low, and as you might imagine, they vary by country income level. So it's not always about patents. The second area where we've seen that recently is with the COVID vaccine and the proposal to break the patents on vaccines so that they can be manufactured more readily in the developing world. While there are merits to that proposal, I think the immediate barriers to production in the developing world have nothing to do with patents. And the danger with breaking patents is that you destroy partnerships that provide what is really needed in those countries, which is the technical knowledge and know-how to be able to produce these incredibly complex and fragile vaccines. So sometimes breaking patents, I think, can be kind of a crude remedy that can undercut the kind of cooperative approach that might get us quicker and more safely to the outcome we need. And then the third thing that I'd mention is that patent preemption is a real issue, and it is a weapon that the drug industry is now wielding against states that seek to regulate drug prices. We have a federal scheme that provides intellectual property protections to patent holders, and when states regulate price of patented goods, there is an argument that is unconstitutional because it is a lower level of government trying to trump a regulatory scheme at a higher level of government, and preemption prevents that. And so what's going on right now is every time a state tries to do anything that has the effect of regulating a drug's price, the drug industry immediately sues the state, arguing that is preempting their patent rights, which simply can't be right. States regulate the prices of all kinds of consumer goods, regardless of whether they're patented or not patented. But I was just on a legislative work session yesterday, and I could see the chilling effect that the threat of this kind of lawsuit has on lawmakers that are struggling now with pandemic budget cuts. They're very much chilled from trying to take action. So it's very dispiriting to me to see the industry abuse its intellectual property rights in that way.
Now, this is fascinating as a political economist, political scientist. Of course, it all seems to be coming back to politics and the ways in which we find means to cooperate. I want to, again, shift the subject a little bit. One of the things that you're working on, Michelle, has to do with a whole series, or many of the things you're working on have to do with a whole series of questions in which there may be an issue of mandatory requirements for the public or not. So mandatory contact tracing and testing, vaccines, vaccine passports. I mean, how do you think about that, not just as a legal scholar, but the ethics of that and the feasibility of those processes?
Well, as I mentioned, there is this very well ingrained principle in public health law of the least restrictive alternative, that as a constitutional matter and as an ethical matter, we should adopt the policy that burdens individuals the least while still achieving the public health goal. The difficulty is how to figure out whether these less restrictive policies are as effective or nearly as effective as more restrictive policies. And so the natural tendency is to want to start with purely voluntary approaches and then kind of work your way up to mandatory approaches. That's usually the way things work. But that really requires a commitment to assessment, as Hank would say, to monitoring and evaluation. And most of the time we don't have that commitment in place. And so what can happen instead is we go with the the easiest solution, the sort of opt-in or purely voluntary solution, and then we kind of walk away and hope for the best instead of saying, as I think we should, we're going to do a time-limited trial of this, we're going to carefully evaluate it, and if this particular trigger isn't clicked in 2 months or 6 months or whatever it is, and we have to go to the next thing. Or if we have evidence that it's very unlikely to work, we have to go to the next thing. So I think digital contact tracing apps are a great example of where this principle has played out. Apple and Google, they're just fundamentally oriented in their partnership towards privacy protection and towards being at least intrusive as possible. So they built a system that frankly had no chance of success because there was absolutely no way that they were going to get opt-in participation by a sufficiently large share of the public to make contact tracing work. That's a system that requires network effects, right? It doesn't work if 10% of us do it. But not only was there no willingness to kind of immediately jump to the higher level, there wasn't even a plan in place to kind of assess how they would jump to an opt-out system, let's say, if they found, as they did, that very low levels of participation ensued, if they required people to take affirmative steps to opt into that system. So, there's an example where I think we have to have that kind of framework in place and be committed to it if we're going to start with the least restrictive alternative. Now, what's going on with COVID vaccines is another interesting example that's playing out in a different way. We started with a purely voluntary approach, and we had a situation of resource scarcity at first, so that of course made sense not to try to push it onto people who didn't want it. Now we don't have resource scarcity. Now we have vaccine abundance, and we have a fairly large contingent of people who are either vaccine hesitant or vaccine resistant. And it's been very interesting to me to see over the past, literally, I would say 6 weeks, how readily private institutions have jumped towards the idea of a vaccine requirement, including, as you know, Margaret, our own institution, Stanford, which joined a number of other colleges very early on in announcing a mandate for students, and then shortly afterward for staff. And that's pretty atypical to see institutions jumping over all of the intermediate incentive-based things that they could do and reaching for mandates. And I think that requires some scrutiny, particularly as we approach the fall and begin to think about what public and private schools should do. Very
interesting. I also know from some stuff I've been doing that the vaccine case, the hesitancy, the first strategy was one size fits all, and now there's beginning to be real attention to the diversities in the population and why certain messaging and certain incentives work for some groups and not for others. Hank, you want to?
Yeah, I just would, I agree with everything Michelle said about it, but would emphasize the importance of nuance in all the intermediate positions between completely voluntary and completely mandatory. And there are a lot of things in between. Even the Stanford mandate for faculty and staff says, we understand that there will be people who will not get vaccinated for religious or medical or other reasons.
Right.
If they need to come to work, they will have to get a COVID test once a week, and they'll have to do the health report and so on. It's not as mandatory as it sounds, but there's inconvenient stuff that you've got to go through that becomes an incentive to get vaccinated. So it says it's a mandate. It's actually somewhere in between, but it certainly has nudges in it. And there are lots of variations that one can do between completely voluntary and completely mandatory. And we just need to be conscious of those.
And it sounds like it's a moving target, because as we create new problems or experience new problems, we have to think about the process for that particular situation.
Yep. And the remaining unvaccinated population keeps changing as well.
Absolutely.
You pull some people out and what's left is different.
Absolutely. Hank, I'm going to now turn to some really big questions and look at you for them. So part of what you study really hinges on questions of the future of human reproduction and de-extinction, which is, of course, the other side of human reproduction. So what are you thinking about those things? You throw those big words out. Tell us what you're thinking.
In 3 minutes or less.
In 3 minutes or less. We have 5 minutes, actually.
So,
and we want to give, you have 4, because we want to give Michelle at least a minute to close.
So first, I think that human reproduction is highly likely to continue to be more infused with science, and particularly, but not exclusively, with genetics, through non-invasive prenatal testing, through pre-implantation genetic diagnosis, to some extent through gene editing. I think we are likely to do that in ways that are not catastrophic, in part because we care a lot about the health of babies. And so we are going to be more careful about things that might affect the health of babies than we would in some other circumstances. And also because the people's deepest worries are things that, at least for now and the next several decades, seem to be scientifically implausible. The super babies, the designer babies, the X-Men, we don't know how to do that. We don't know genetic variations for safe genetic variations for substantial enhancement. So I actually think genetics will continue to play an important role, particularly with respect to limiting diseases, that raises a whole bunch of issues, particularly in disability rights spaces and concerns. But I don't think we're going to see a speciation event in the next 50 or 100 years, who knows? 100 years from now, who knows anything? I do think, though, that we are much less constrained in dealing with non-humans. And so the book I'm working on now is really about how our biosciences applied to non-humans are going to change the biosphere in ways that both have economic rationality and ways that are just frivolous, make green dogs because we can. And I think that's going to be probably, at least in the next few decades, much more significant for humans and for the world and the biosphere than what we do to ourselves. Our species has been changing itself in infinite ways ever since we existed. Agriculture changed us, reading and writing changed us, the internet changes us. Maybe one of these days it'll be a qualitative change rather than a quantitative change. Not in my lifetime, I think.
Michelle, I'm going to give you a last word here, and then I will thank you both. And
well, I'm not sure I have anything really to add on this topic. My interest in the reproductive health realm has primarily been around what's going to happen with respect to abortion law under the Supreme Court, but that's a very different direction from the one Hank took us in.
But do you have a final statement you want to make about your domain, the things that you're interested in, something we should take away about the ethics and legal responsibilities of us all?
Gosh, I don't know that I do, Margaret. That's pretty big to try to sum up in the last minute. So maybe I'll just thank you for hosting this conversation.
Well, I thank you both for participating in this. This has been really amazing. And our initial effort at having a good conversation and unintended consequences, sponsored by the EST Hub, the Ethics Society and Technology Hub. So thank you both for being our guinea pigs, as it were. We'll do some evidence-based assessment of this and hopefully have other conversations.
Wait. Was this IRB approved?
Yeah, it was.
Oh,
Or Ethics and Society Review Panel approved.
Okay.
And with that, do you want to say something else, Hank?
Thank you, Margaret. It was fun.
Thank you both. Very fun. Bye.
Thank you. Bye, everyone.